That was Prime Minister Trudeau speaking in Scarborough, Ontario. Now, he was commenting on SNC-Lavalin's court filing today, asking the Federal Court of Appeal to give it another try at winning a deferred prosecution agreement on charges of fraud and corruption. Now, the company is accusing the Federal Director of Public Prosecutions of abusing the legal process. The company's challenge is based on new information arising from the Justice Committee hearings, including testimony from former Attorney General Jody Wilson-Raybould. The company claims that Wilson-Raybould made a decision not to intervene in the criminal prosecution without knowing additional information supplied by the company. SNC alleges that the Director of Prosecution had received additional information but did not pass it along to Wilson-Raybould for her consideration. Just last month, the federal court threw out the company's first request for a judicial review of the decision not to give it a deferred prosecution agreement. Well, joining me now to look at all of this and this latest development is Jennifer Quaid. She's an assistant professor of law at the University of Ottawa and a specialist in corporate criminal liability. Thank you very much for coming in.
Thank you for having me.
It was only weeks ago you were here with my colleague Peter Van Dusen commenting on the first court decision of the federal court. If I remember correctly, when the first decision was rendered, one of the key decisions by the federal court was that the Director of Public Prosecutions has total discretion, has prosecutorial discretion, and they threw out the previous request. It seems to me the first part of this request is saying, no, we have cause, we can question the decision by the DPP.
Yes, so this notice of appeal does already challenge the basis on which the initial application was brought. Yeah. And they said this kind of discretion that's exercised is different from regular prosecutorial discretion and therefore should be subject to judicial review. And so they're challenging the judge's conclusion that no, it's not. It's the same as regular prosecutorial discretion and isn't subject to judicial review. It can only be challenged for abuse of process. But now they go one further, and that's the big difference, and that's what all these new pieces of the notice of application are about, is that on the basis of things that Jody Wilson-Raybould testified about and information that has now been circulating in the media, including statements made yesterday, which are not fully confirmed as far as I know, they are now challenging the exercise of the discretion itself as being an abusive process, which is the standard that you have to meet to challenge ordinary prosecutorial discretion. So if they don't succeed on saying this kind of discretion is different, they're also now attacking the exercise of discretion itself as being an abusive process.
Okay, so what do you make of this case? I mean, they're saying, the one thing that caught my eye was that they're saying Jody Wilson-Raybould may have said, I made my decision, but she wasn't even given all of the information.
Well, so one of the things that, and we've all read this notice rather quickly, is that, of course, the only two parties that really know all the information here are SNC and the prosecution service. Okay. Now we have a lot more pieces of the puzzle that fit together. The timeline is becoming a little clearer. What was said, information that was exchanged. It seems now quite clear that SNC was not told specifics. It was given an indication that the answer was going to be no on September 4th. Then they say, please, can we give some more information? They say yes. This is not with the Director of Public Prosecutions, but with the line prosecutor who's actually handling the file. And then there's suggestion that there are little bits of information that come out. Now, it's still not clear to me that we can conclusively say that the information that the Director of Public Prosecutions got was not given in some way to Jody Wilson-Raybould. I think we would need to have a definitive, indication of what happened there. The lawyers here are filling in the gaps and they're making reasonable suppositions, but I don't know that we have definitive proof that Jody Wilson-Raybould was not informed and made her decision without the benefit of that information. And I think that in some ways, that's maybe not going to be the most crucial part of this. I think the crucial part of this that they're really hammering at this point is that there's some significance in the fact that we talk about the decision not to invite to negotiate, because it's not the decision to award an agreement, it's the decision to invite to negotiate. It's the first step. Yeah. Was not appropriate. And they're fixing on that as being, oh, well, that means since this decision is supposed to be appropriate and in the public interest, we're taking for granted that the Director of Public Prosecutions must have thought it was in the public interest and it was only not appropriate. I think that is, of course, a clever legal argument. I'm not sure that's going to go all the way, but the real question to me is going to be what really motivated the decision. And this may force the prosecution service to show its hand. It has not until now wanted to do that, and there are good reasons why they don't want to make a habit of doing that. But this may be the case where they're now going to have to reveal in more detail what motivated them to come to that conclusion.
Okay, so what you're saying is that one of the difficulties in any of us sort of arbitrating this is that we have not had a chance to know on what basis the Director of Public Prosecutions didn't even offer the chance to try to apply for a
That's
deferred
right,
prosecution.
that's right. And
we just don't know.
That's right, we don't know. And right now, again, on the basis of sort of little logical inferences, the lawyers for SNC are very cleverly putting together a story. I'm not sure that they're of course arguing on one side of litigation.
But it could force
so
the
it's
hand.
it's normal that they're emphasizing the things that support SNC's position. I don't think that we can yet come to a conclusion that the decision was done hastily or without consideration, and they're suggesting that that's the case. I'm not sure that we can really go there.
Okay, but 2 points. One, you say it might force the hand of the Director of Public Prosecutions to give more information, make it public, make it available. But 2, what is the importance if Jody Wilson-Raybould wasn't given enough information? Is that relevant at all in terms of her? Because the argument is that she should have kept herself abreast and kept asking for new information, and that would be the political point where her political superiors, the Prime Minister, was saying that maybe you should intervene.
Well, here is my take as a legal expert who's not, obviously an expert on the politics. The role that Jody Wilson-Raybould could have played is an extremely limited one, which is that she could have issued a directive to the Director of Public Prosecutions, directing the prosecutors in this particular case to do something different than what the prosecutors had decided in their discretion, and that is to invite SNC to negotiate. That's what she could have done. There's been no talk, even though it's theoretically possible, it's never been done, for her actually to become the chief prosecutor in the case. She wasn't going to do that. So it's really whether she felt that she should issue this directive to the Director of Public Prosecutions. And actually, I'm really not sure that more information and continually revising that was really intended here when we gave the power to issue directives to the Attorney General. It's not really an appellate power. It's not like that they're reviewing they get many notices from the prosecution service about cases that are important, but we don't expect the Attorney General to be personally overseeing and intervening. Maybe one can make the case this was the first remediation agreement situation, and maybe there should have been, but she made a decision that decision could stand. Should she have had more information to decide that was a good decision? I don't know. We need to know whether, in fact, she was not informed and what that information was before we make a decision, I think.
Well, this is where we say thank you very much, and we wait with bated breath to see what that information might be if it's made public.
Yes, indeed.
Okay, thank you very much. Something tells me this won't be the last time we talk about this. Thank you. Thanks for coming in.
Thank you for having me.